Thank you very much, Mr. Raskin.
Mr. Armstrong, always a pleasure to see you. You were one of, I think, just 2 former public defenders in Congress, right? Is it you and Cicilline? Is that right?
Yes, I don't know if Morgan Griffith did public defense, but he did do some criminal defense.
Yeah, well, I want to thank you. I take you from our years together in the Judiciary Committee to be a serious lawyer, and I want to thank you for conceding the legitimacy of the January 6th Select Committee's legislative function and purpose. On that, you concur with the courts, and you're against, I'm afraid, the leadership of your party, which continues to say there's not a legitimate legislative function or purpose there. Will you just elaborate how you came to that conclusion?
Well, I mean, I read the Trump v. Thompson case, and I mean, listen, a very good district court judge told me one time, Mr. Raskin, even the courts aren't always right because they're smartest, they're right because they're last. And there's a ruling, and at least in this specific case, there is a court ruling when the Supreme Court failed to hear it that acknowledged the Select Committee's legitimate legislative purpose.
And I mean, the basic logic here is that if the Congress cannot investigate an attack on Congress, an attempt to overthrow an election, it's hard to think what we could investigate. But thank you for that, and I mean that sincerely. But I want to ask you this. Because of your experience as a public defender, and you just talked a moment ago about how, whether someone's going to civil court for a divorce proceeding or a criminal court for a murder trial or a parking ticket, whatever it might be, they're owed due process. Did you ever have a client, or can you imagine having a client who is subpoenaed to come testify about something, who thinks that their testimony could implicate them, who you would advise just not to show up? What would you advise someone who says, I'm nervous, someone I know is being prosecuted for something, and I'm afraid if I respond to this subpoena, it might implicate me? Would you tell them not to go?
Well, it depends where the subpoena is issued.
Well, a criminal court or civil court, as you say.
But this is important because this is where we end up in this fight. We say, you have adversarial sides in this proceeding, and no independent arbitrator showed up. If an independent judge tells you to turn something over, I would advise them to turn it over.
Wait, but are you rejecting the long line of authority going back to the beginning of the Republic that Congress has all the authority of a court to subpoena people's participation in a proceeding?
And they have and the person being subpoenaed has the absolute right to have an independent arbitrator determine that. I believe that. Okay, do you have any authority for that? Sure. You can go to court to object to a subpoena. You can go to civil court to enforce a subpoena. We've been through this.
Well, okay. So here, though, there is one legal document that there's one legal command that's at issue, which is the subpoena from the House of Representatives. That is like a court ordering you to do something. If you don't like the ruling of the court once you get there, you can appeal it. And as you were just saying a moment ago, you can go as far as you can go appealing it, but you can't blow off the court. I mean, did you ever have a client who you told just don't show up if you think you've got a Fifth Amendment privilege or any other kind of privilege? No, I assume you're being an excellent lawyer. You would say you go to court, and when they ask you questions X, Y, and Z, you assert the Fifth Amendment, or the marital privilege, or whatever privilege it is, right? I'm sure you did that countless times in your career.
Yeah, but I don't agree with the correlation. I mean, I've had plenty of document requests and subpoenas in which we have gone to a court and fought about them, and I've had plenty where I've forced prosecutors to enforce them.
Yes, you've gone to court, but you haven't just refused to show up. That's what these guys have done. They've refused to show up.
Well, I don't think Mr. Scavino just refused to show up.
Did he go to court?
Mr. Scavino engaged with this committee for 9 months straight and never got real answers.
All right,
okay. The committee's enforcement action is a civil enforcement action.
All right, let me ask you this. To whom does the executive privilege belong? Who gets to assert it?
Well, President Trump has asserted it with Mr. Scavino.
But as a matter of law, who gets to assert the executive privilege?
The executive.
Okay, so it's not a private party. Scavino can't assert the executive privilege, right?
I don't think he's arguing that he
Navarro can't assert the executive privilege. The Supreme Court held in United States versus Reynolds in 1953, and multiple times since then, the executive privilege belongs to the government and must be asserted by it. It can neither be claimed nor waived by a private party. Do you have any precedent that contradicts this?
Well, I have US v. Nixon, which says that a former president has abilities to have privilege.
Okay, let's say that were the case, okay? And it's dubious given that the D.C. Circuit just held the privilege, like all other Article II powers, resides with the sitting president. But even if that were the case, how does that help Mr. Navarro? We haven't heard from Donald Trump. Navarro hasn't given us anything saying Donald Trump is trying to invoke executive privilege for him. So how does that help Navarro?
Well, I mean, I would have, listen, if I was Mr. Navarro's lawyer, I probably would advise him to do some things a little differently.
To come in and testify, right?
Well, we're in the middle of one contempt rule, one contempt order. So as we continue to move this, it seems like the rule doesn't make any distinction between Navarro
Okay, well, let me ask you then about the content of it. Do you concede that the executive privilege applies only to the valid work of the executive branch? Can a president, assert executive privilege for political campaigning that he's involved in or one of his subordinates is involved in on their own time?
I don't even know if I know the answer to that. I haven't looked at it.
But the answer is no. I mean, the Hatch Act makes it a crime for someone to engage in political campaign work on their job. So essentially, you'd have to be saying, well, I was violating the law and doing as part of my job campaign work. So the answer is no. Much less can you assert the executive privilege for criminal activity. Would you concede that point?
Well, that's the line that I think is important and also where the distinction lies in US v. Nixon.
Yeah, well, I think that's where we are because the investigation that we're doing under House Resolution 503 is into a massive violent assault on the Congress, the first successful effort in the history of the United States to interrupt the counting of electoral college votes in order to overthrow an election and to falsely continue a presidency, to seize the presidency for the first time in American history. That's criminal activity. So the idea that executive privilege could cover anything related to it is just fantastical. It's preposterous. But I appreciate you're in a tough position. I think you've done a pretty good job given what you're defending there today. I really do. And I thank you for conceding the legitimacy of the legislative purpose and function.
If I may,
please.
I would just say the best place to investigate criminal activity and probably the only appropriate place is the Department of Justice and not the House.
Yeah. Well, we're not prosecuting anyone. Our charge is to try to determine what happened, why it happened, and how to make sure it never happens again. Nothing could be more serious than the protection and the preservation of democratic institutions. And that is why this is a legitimate legislative purpose and why the overwhelming number of people have cooperated enthusiastically with the investigation. Thank you for being here today. I yield back.
Thank you. Ms.